A big development today in an ongoing legal battle with major stakes for our democracy and the question of whether everyone in this country is equal under the law. A federal appeals court today has upheld a gag order limiting what Donald Trump can say in the federal election interference case. The three-judge panel that decided the issue has, however, narrowed the gag order. Statements by Trump about special counsel Jack Smith, they are now fair game. Comments about court staff, other lawyers, are barred. Quote, if those statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel's or staff's works in this criminal case, or with the knowledge that such interference is highly likely to result. And as our friend Lisa Rubin notes, while Judge Tanya Chutkan's previous order barred statements, quote, targeting witnesses, the new version of the gag order prohibits all, quote, public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in the criminal proceeding. The judges say that the ruling is an attempt to strike a careful balance between Donald Trump's free speech rights and his position as a candidate for president and the need to protect the judicial process in one of the most high-stakes cases this country has ever seen. Judge Patricia Millett writes, we do not allow such an order lightly. Mr. Trump is a former president and current candidate for the presidency, and there is a strong public interest in what he has to say. But Mr. Trump is also an indicted criminal defendant, and he must stand trial in a courtroom under the same procedures that govern all other criminal defendants. That is what the rule of law means. And that is where we start today with former lead investigator for the January 6th Select Committee, Tim Heaphy, former chairman at the RNC, Michael Steele, and here at the table with me, Democratic strategist and director of the public policy program at Hunter College, Basil Smikle. Gentlemen, it is good to see you all. Tim, your reaction to the appeals court ruling?
Yeah, as you said, Alicia, it's an attempt to balance. This is an unprecedented terrain for any judges that they've ever had to face before, a criminal defendant who is simultaneously a candidate for president. The appeals court, much like Judge Chutkan, is trying to protect the defendant's rights to free expression, but also protect the integrity of the process. And I see the logic here, right? The former president is allowed to criticize the process, to criticize the motivation of the Justice Department. And now, after today's ruling by the appeals court, Jack Smith himself, he can't, however, challenge the integrity or say anything intended to influence actual potential witnesses. That is the key, right? It's the potential attempt to say things that put pressure upon or influence witnesses or unfairly disparage them that the judge is protecting. So, again, we're going to see a lot in this case that is new terrain for any appeals court or Judge Chutkan. There's going to be a lot of balancing going on. I think here the appeals court's done a pretty good job trying to strike that balance.
Michael, I want to read just a little more from the ruling. Quote, like any other criminal defendant, Mr. Trump has a constitutional right to speak, and his millions of supporters, as well as his millions of detractors, have a right to hear what he has to say. Also, like any other criminal defendant, Mr. Trump does not have an unlimited right to speak. Michael, how do you see this playing out?
I get it. I understand the space the court finds itself in. But here's the problem. They still don't understand the defendant in front of him. I get what this ruling tries to do is split, the proverbial, unsplittable thing. And the reality is that's the problem. Donald Trump knows that's the court's problem. So they want to protect the witnesses, but now they have opened the season on the prosecutor himself. Don't they realize that is how he's influencing the witnesses? Because they will now have a further jaundiced view of the prosecutor. You don't think that bleeds onto the case? You don't think that bleeds into how those people will now understand what Jack Smith is doing in prosecuting Donald Trump? So when Donald Trump gets up and calls Jack Smith a son of a bitch, and that, he's a danger and a threat to the process, you don't think that's going to influence that one little juror that's sitting out there and goes, if they picked, this prosecution was a threat to the process, not so much to Donald Trump, because remember, he's already said, if they come after me, they're coming after you. So now all these folks have a chance to put themselves in those shoes. So I get the problem the court had, but the reality of it is you're dealing with a defendant who's using the system against itself and cloaking himself in the red, white, and blue of the presidency to say, you can't touch me. Oh, by the way, the prosecutor's a son of a bitch.
Well, Tim, there's this question of what it means for jury selection, how it potentially complicates jury selection. There's also the question of what it means for Jack Smith, what it means for Jack Smith's staff. We have seen in the past when Donald Trump chooses to make a person his target, what ensues.
Yeah. You know, one thing that it helps with as a legal issue, that the president is going to argue repeatedly that a lot of these rules that apply to other criminal defendants don't apply to him. He's made that argument that he's immune from prosecution because these acts occurred while he was president of the United States. The appeals court today, as a threshold matter, ruled he must be treated like any other criminal defendant. So there's a threshold victory here for Jack Smith, that the president has been treated as any other criminal defendant. Now, admitting that there are some unique circumstances, he's a candidate, he has a First Amendment right to criticize matters of policy, but he's been held to the standard of a criminal defendant. That will be repeatedly cited in other contexts. Now, you're right, Alicia, when the president singles people out, anyone, it creates significant danger. Jack Smith and the others who are directly engaged in this case have to be protected. And I believe that they are. Right? Any person who is engaged in a matter like this will enjoy the protection. But as Michael said, criticizing Jack Smith is criticizing the process, and that will have ripple effects on others. It is an imperfect balance, but the court trying very much to protect participants but protect his free speech right.
Imperfect indeed. I want to bring into the conversation former Deputy Assistant Attorney General and former U.S. Attorney Harry Litman. Harry, Trump, he just posted on his social media account he will appeal. Not surprising, of course, but then talk us through how that plays out.
Well, the appeal, I mean, we're the D.C. Circuit here. The appeal is going to be in the form of an appeal to the Supreme Court. I don't see it going anywhere. And I think the most significant thing, first, I want to say Tim's point is really important. Thematically, he was trying to say, A, I'm special, and B, this is a special First Amendment issue. They said, A, no, you're not, and B, you're just, this is a defendant issue, integrity of the trial issue. You know, Jack Smith and prosecutors are used to being under fire. That kind of goes with the territory. If it does actually begin to impute the process, Chutkan remains free to modify the order, and I think everything about the D.C. Circuit opinion today says they will be behind her. We thought they might have modified the legal standard, but they didn't. In terms of the court now, unless they stay it while he considers it, which he'll ask for, really the game is basically over. I don't see this as being, with so many things on the horizon, the attack that they will, I mean, the issue that they will glom onto. If they did, yes, everything would be frozen and he could just continue to run his mouth. But he's effectively at the end of the road here, I think.
Okay, so Basil, that is the actual courtroom in the court of public opinion. We know, based on experience, that Donald Trump will add this to his list of grievances and paint it as victimhood.
Right. That's why, you know, when Michael was talking earlier, it made me think of something I talk to my students about in many ways, that there are different types of power. There's this sort of direct hierarchical power where if you think about the military, I tell you do something, you go do it. But then there's the power of just my presence, just me being in the room or not in the room. That influence causes you to act because you want to support me. You want me to benefit from your action. That is an extraordinary amount of power that Donald Trump knows very well how to utilize. He doesn't have to be in the room.
In a civil fraud trial.
That's right. He doesn't have to be in the room. He doesn't even have to say it through his lips. He just has to be able to sort of send a signal, whether it's to Jack Smith in his attack on Jack Smith, or just the fact that he has engaged Trumpism in the way that has turned it into a cult, where the folks who support him will just act anyway. Yep. And that's what's so scary. Look, I think Tim's point earlier is correct in that this largely upholds Judge Chutkan's, the basis of her decision. But to go to some of the comments that were made, let me go to the glasses for a second, torrent of threats and intimidation and a pattern of real-time, real-world consequences. So there is this awareness that he can cause damage and that he's a danger to others. But the reality is that trying to put a muzzle on him actually doesn't really do the job you think it's going to do, because what he's already done and the way he's primed his supporters already means that you have to go after it further and further away from him. And that's the struggle we have today. Look how much Trumpism is embedded in so much of our country right now.
Watching those reading glasses go on and off at this table remind me so much of Nicole Wallace. I miss her so much. Right. Tim, I want to talk to you about enforcement of this order, both in terms of sort of the legal document itself, the legal framework, and how easy or hard that is to enforce given who it is we're talking about here. But also this point that Basil makes, which is a really smart one, which is, you know, Donald Trump, more than anyone, he knows how to use language and rhetoric, even if it is within the confines he has been given, to signal to his supporters what it is he wants.
Right. And he has a lot of surrogates. This applies to him because he's the criminal defendant. It does not apply to other people who speak on his behalf or who share his political interest. Judges don't have a lot of remedies when it comes to enforcement of gag orders. They essentially can either fine a defendant, unlikely to be very compelling for a person of the former president's means. They can order a person confined for failure to comply. That would be a pretty high threshold. It essentially means the only way to guarantee that he adheres to this order is to incarcerate him. I think that would take something really directly egregious. So it is very difficult for Judge Chutkan. As Harry said, she can reassess the order. She can call him back into court if there are alleged violations, have his lawyers answer for that, and consider imposing further restrictions. But there just are not a lot of tools. The biggest tool, and the one that I think I continue to say the most likely, is it makes that March 4th trial date increasingly firm. Like the best way to prevent really incendiary pretrial statements is to get the case resolved. So the more he talks, the more dug in I think Judge Chutkan and the process is on March 4th of next year.